The Department of Justice is asking the Supreme Court to keep access to an abortion pill free of restrictions imposed by a lower court ruling.
The DOJ and the drug manufacturer filed separate emergency requests today. A federal appeals court ruled Wednesday that mifepristone could stay available, but with new limits, including a ban on sending the pill through the mail. The department wants the justices to put the decision on hold pending an appeal.
CBS News legal contributor and Loyola Law School professor Jessica Levinson joins us now. So, Jessica, how is the Supreme Court likely to respond to these requests from the DOJ and the drug manufacturer?
I wish I had a definitive answer to that question. I think there are some indications that if the Supreme Court follows what is typically the law for imposing a stay in any case, then they should just push pause on the entire decision that was made by Judge Kaczmarek last week. Because legally speaking, you implement a stay when you want to keep the status quo, when it actually causes more chaos to change the law as the case is being litigated, which is what's happening now. On the other hand, this is a very conservative court. This is the same court that overturned Roe v. Wade. And so it's difficult to say for sure, in my mind, that they would follow the legal underpinnings of when we need a stay. And it really is, can you count to five? Can you count to five people who are willing to push pause on this ruling?
So, Jessica, if the justices don't approve the department's request, do we know yet what that means for access to the drug nationwide?
Yes and no. And this is where things get complicated. So the Fifth Circuit yesterday said basically yes to half of Judge Kaczmarek's decision and no to the other half, just with respect to the stay. So what this means for people today, if the Supreme Court does nothing, is that mifepristone is still approved, that the approval is not suspended while the case is being litigated, but it's as if we're living in 2015 before the FDA made changes to make it easier for people to obtain mifepristone. So those changes were, for instance, that you didn't need to go into a doctor's office and have 3 in-person appointments, that you could now use mifepristone not up to 7 weeks of pregnancy, but up to 10 weeks. So currently, as it stands, the Fifth Circuit yesterday basically said, we can suspend those changes that the FDA made to make it easier to obtain mifepristone. Now, I wish I could say this without it sounding complicated, but there's one more wrinkle here, which is that there was a Washington state federal court judge last week who also said in a somewhat conflicting decision for 17 states and the District of Columbia, don't make any changes, FDA, to the status quo. Don't make it more difficult in order to obtain mifepristone. So at least for those 18 jurisdictions, there's a real question as to how they can comply with both of these rulings.
So with that in mind, do we expect the justices will actually weigh that decision as well, Jessica?
So I think that the justices, based on these emergency appeals, obviously they're aware of what happened in Washington, but they need to take each case alone and they need to look at the facts of this particular case. It's the appeal from Texas. And I think, again, when you weigh all the reasons that you put a temporary stay on a case, they all in this case weigh in favor of saying, let's pause that Texas court decision. Let's not make any changes to access to mifepristone, at least while we're litigating the merits. Because again, this isn't the merits of the case. What we're talking about now is just which parts of that decision are put on pause while the case works its way through the system.
Certainly not the last time we'll be discussing this ongoing fight. Jessica Levinson, thanks so much for joining us.
Thank you.